All right. So I think for this section, I wanted to actually delve into a particular case. But before I do that, there were some questions really good questions people had during the break. But is there anyone who wants to raise a question in the larger room? Yes, please. Please say your name and where you're from.
Good morning, ma'am. I'm Sumi from ALCO. I'm representing ALCO. I'm from India. So I had a question with regard to a couple of slides back. You discussed the counterclaims which could be filed by states. So I don't know if it's a relevant question, but I was just wondering if there is an issue of limitation period involved when a case files a counterclaim, a state files a counterclaim. Like, can they be asked questions like, why didn't they file that counterclaim before the claim was filed by the investor?
Yeah, excellent question. Typically, no, and for this reason, that the state would have to demonstrate that this was the same dispute, in a sense. And so the counterclaim arises out of the same dispute that the claimant had submitted. Sometimes, and it's not a complete restriction, sometimes there's the ability to actually lodge a dispute that may be related, because obviously it's the same claimant entity, but not precisely the same dispute. So that's a question that has been part of how tribunals have considered the language of all disputes, whether it's sufficiently broad in order to encompass counterclaims. But what's interesting and embedded in your question is, limitations, periods, et cetera, apply in the ordinary course. So for example, if the state lodges a counterclaim that falls outside of jurisdiction ration temporis, for example, of the treaty, then the claimant would no doubt say, this counterclaim, there's no jurisdiction because it falls outside the temporal scope of the treaty. So the same basic rules of jurisdiction admissibility would apply, but what's encompassed in the treaty, that is the restrictions on state consent, the specific, for example, timing, cooling off period, that wouldn't necessarily apply because that's really for claimant to respondent. So the short of it is, it depends on the language of the treaty, it depends on the circumstances, but the question really revolves around what that all disputes language means when it comes to the ability of a tribunal to consider a counterclaim. Yes, please.
Can a country establish its own arbitral tribunal? For example, that arbitral tribunal will have jurisdiction to receive cases between the state and its own state and foreign investors, and perhaps also between investors within the same jurisdiction. Thank you.
The short answer is yes, subject to agreement. It would be fairly unusual, but not unprecedented. It would have to be baked into the investment treaty itself that the dispute resolution of foreign investor claims would go to a specific body. And that specific body could be an arbitral tribunal that's set up by the host state. One caution is that it may be that the host country wants to set up an arbitral tribunal so that it streamlines the adjudication process. But the country that is the nationality origin country may feel that that's not sufficiently neutral, that is an actual fair adjudication. So it's going to be, as with all things, a negotiation between the host country and the country that is the foreign investor arises out of. And that, I think, would be an interesting construct. When I'll get to in a minute on the ISDS potential reforms, there's actually a potential, and the EU has spearheaded this, of a type of standing body that is formed and states can opt into it. So instead of having ad hoc tribunals the way that most of these BITs are formulated, it would be a standing body akin to a court. Sometimes it's been compared to, a WTO type court or body that would be a standing body for investment disputes. But again, it's all a matter of, do these two countries, did they negotiate and come up with an alternative to the usual arbitral panel approach that's under ICSID or under UNCITRAL? Yes, please.
So you spoke a bit about the two sets of rules from the New York Convention and ICSID. I was wondering if assuming that there are no jurisdictional concerns, would that be certain advantages to a state choosing between each rule for certain types of disputes?
Great question. And the answer is yes. One example is there are some particular provisions of the ICSID Convention that apply to these types of investment claims, which in some circumstances may be an advantage to the state versus the claimant. In other circumstances, it may advantage the claimant versus the state. So in the strategic conversations about what is the best place to lodge a claim, that will come into play. And for example, under the ICSID Convention, there's particular nationality requirements. There's a particular requirement that the investment must be material enough or rise to the level of actually having material impact on the economy. There's different types of tests that apply. It's called the Cellini test. So when claimants have assessed which option to use under a BIT, they usually will have done it on the basis of making some strategic judgments. Now, of course, a respondent state just gets the request for arbitration. The claimant is already elected, and then the respondent state typically has to go with it because they've consented. But I have been in a situation where I've advised claimants, because one versus the other, if the BIT allows for either choice, one versus the other is strategically advantageous. All right. So I think for this portion, we really wanted to talk about a particular case, and I'll talk about it in general terms. And it actually, you'll see, puts all these considerations that we've been talking about in the context of an actual case that's played out. And all of this is public, of course. But to start, to give you a sense of a life cycle of an international arbitration, it's very process-oriented, as you can imagine, as any international legal proceeding, or frankly, even a national leading proceeding would be. And it has different phases. So you start with the notice of dispute, often an exchange of initial submissions. The exact details of this depends on whether you're proceeding under the ICSID Convention, under UNCITRAL, under some other institution, but generally speaking, it falls within these parameters. The tribunal constitution, which we've talked about, which is particularly important, usually happens in the first 3 to 4 months of initiation. There's evidentiary submissions, discovery, often hearings, sometimes bifurcated in order to have a jurisdictional disposition before you get into the merits. Sometimes jurisdiction and merits are married. That's a big strategic question for respondent states. Then sometimes there's post-hearing briefing, the award, and then there's the post-award proceeding. So generally speaking, this is the life cycle of an international arbitration. So the claim that I wanted to talk about is interesting because it has a lot of basic facts that resonate with some of the themes that we've been discussing. And it's the Hydro Albania case. It's a case that arose under the ICSID Convention, under the 1996 Italy-Albania BIT, which obviously allowed for ICSID arbitration in the dispute resolution clause. The claimants were 5 Italian claimants, 2 companies, 3 individuals who initiated the arbitration in 2015. They alleged a whole myriad claims, including expropriation, unfair and equitable treatment of investments in Albania, had to do with some energy projects, but I'll focus on one aspect, which is a broadcasting project. And full disclosure, I was involved as counsel in the case. So the claimants alleged that Albania had targeted them with police powers, but police powers exercised on an unfair and discriminatory basis. So the basic crux of their claim is that the tax charges, criminal money laundering charges, the tax evasion, other criminal charges that were lodged against the individual claimant and companies were pretextual, that they were actually the exercise of police powers unlawfully for the purpose of harassing and retaliating against this company, ostensibly for unfavorable media coverage by the media channel that was owned by the company against the Prime Minister. So it was one of those classic and interesting intersections between investment arbitration proceeding and public order, media freedom type rights that were being invoked in that context. So in terms of the particular moments and strategic moments of the case, I think probably one of the most important was the provisional measures phase. So for provisional measures, as you may know, there's a requirement that the claimants be able to demonstrate urgency, necessity, irreparable harm. Those tend to be the factors that come into play for provisional measures. They often happen very early in the case. And they're quite powerful because it's one instance early in a case where you get some sense of perhaps how the tribunal is viewing the claims. You get some sense of where the claims are strong, potentially vulnerable, but they tend to be really important moments. And they're also important from a sovereign perspective because it's the first moment where you could have a perceived loss. Now, it's not the full case, but it is an important threshold. And provisional measures restrain what a sovereign can do during the pendency of the case. They are there to preserve the status quo. They do not persist after the case is over, but you have to convince a tribunal that the status quo must be preserved or their claims would be irreparably harmed. And it's a very high burden to show. Here, it was in the context of the criminal proceedings lodged against the claimant's principal, which would have meant that the claimant would be put in prison during the pendency of the proceedings and therefore would not necessarily have full access to lawyers and all of the other things that needed to happen for purposes of the claim. This was, I believe, actually the very first investment arbitration where a tribunal was considering whether or not the exercise of police powers in a criminal investigation, which is obviously a very, very important and significant exercise of sovereign police powers because it's around enforcement of criminal laws, whether that needed to be suspended in order to preserve the ability of the claimants to proceed on their case. Novel question, extraordinarily difficult in the sense of balancing rights of claimants on one side and the ability of a state to exercise legitimate police powers. In order to issue the opinion, basically the tribunal would have had to find that the recommendation of provisional measures is warranted because the exercise of police powers was pretextual. And that's essentially how you can meet the standard in this context. And this is what the tribunal did in fact find in issuing provisional measures and saying that the possible incarceration, and I've excerpted the relevant provision so you can see it, would affect the ability of these two claimants and indeed other claimants to adequately put their cases and participate in the arbitration. The effect of the provisional measures proposed would affect the respondent's ability to proceed with the criminal prosecution in the immediate future. However, a stay would not put an end to criminal proceedings. They would be delayed but not terminated. The respondent also adverts to the possibility of the claimant dissipating assets if the criminal proceeding is stayed. Given that the investments are physically located in Albania, it is difficult to accept that this would be a major risk. The balance of proportionality comes down in favor of protecting the claimant's rights. So I thought this was interesting, but it gives you a sense of the types of balancing that can occur in the context of investment arbitration to try to balance claimant rights and public order imperatives. And this is just one example in which provisional measures were issued. Ultimately, the claimant left Albania and was located in London. There was an attempt by Albania to initiate proceedings, extradition proceedings in the UK. Ultimately, was denied by a London court who found that there was no basis for Albania to do so. So one example also of how these international arbitration proceedings can manifest in different aspects of domestic legal proceedings. So the next phase involved a jurisdiction and merits phase arguments. And there were a few that I thought was interesting from the perspective of giving you a sense of how these types of objections work and how they're disposed of. So Albania's objection focused on admissibility, saying that some of the claims are purely contractual and should be resolved exclusively by ICC arbitration per the dispute resolution clause of the contract. So this was a situation, and similar to what I had mentioned before, where there was a concession contract. The concession contract had its own dispute resolution clause that was an ICC commercial arbitration. And Albania's argument was, look, this is all about the concession contract, and it should not be adjudicated as a treaty breach. It is a contractual breach, not a treaty breach, which is a very salient objection on the part of states. The response to that was that, no, these are sovereign acts that are at issue. They cannot be characterized as purely contractual, even if they might also give rise to a breach of contract claim. And so that was the counter-argument. Ultimately, the tribunal, and you see the decision on the bottom, found that based on the claims as alleged, the offending conduct is constituted by a broad range of abusive measures that go beyond those matters Albania asserts are contractual. If the claimant's factual claims are made out, they would be capable of constituting a treaty breach. So that's the kind of sensibility brought in thinking through, well, if it's just a contractual breach, it doesn't rise to the level of a treaty breach, but when is it appropriate for tribunals to take jurisdiction and analyze sovereign conduct because it rises to a treaty breach? And it gives you a sense of the kind of reasoning. On the merits, I wanted to pull out in particular the expropriation claim. And this is with respect to the alleged expropriation of the media channel assets. So the Agon channel was one of the only independent, they alleged, media channels operating in Albania. Because of the tax and criminal enterprise allegations, the Albanian police came into the premises, seized all the assets, and the employees, in some instances, were arrested, and others, the employees went home or left the jurisdiction. So in that context, the media company alleged expropriation. They claimed that Albania had used criminal proceedings against the claimants to seize the assets, shut down the channel, and therefore expropriated the claimant's investment. And expropriation requires substantial impairment of the value of the investment. So one of the questions is the investment substantially impaired as a result of state conduct? And the other allegation is that this was part of a politically motivated campaign against the claimants and cannot be justified under any of the exceptions under the BIT. So again, that gives you a sense of the kinds of evidence and the arguments that went back and forth. Albania's response is there was no taking. They didn't have the necessary permanent effect, effectively saying that, well, the assets were seized, but they're located somewhere else, and therefore there isn't the substantial impairment because there was no dissipation or permanent effect on the value of the assets, and that they were a legitimate exercise of police powers, which is what you'd expect a sovereign who had initiated criminal proceedings to allege. And the tribunal's analysis on this was fairly salient. They found that there was an expropriation. They focused not necessarily on the measures themselves, which was the seizure, the criminal proceedings, but the practical effect, to find that there was a, quote, permanent deprivation of the substantial value of the claimant's investment. The tribunal was convinced that it wasn't a matter of taking the assets back and restarting the business, but that the business was effectively destroyed. And that rose to the necessary level to find an expropriation. And again, said this could be seen as temporary, but the deprivation and the destruction was material such that the continuation of the investment was effectively impossible, leading to the permanent destruction of Agonset's value. So a very salient kind of focus on the effect versus not necessarily the intent is how the tribunal got there. And then there's a separate section on saying that in the finding that it was not a legitimate exercise of police powers, that it was the, quote, culmination of a political campaign against the claimants, and that was the basis of finding that there was a discriminatory or other unfair intent behind the conduct. So again, gives you a sense of how the power to regulate, the power obviously to do something classically sovereign, which is pursue criminal proceedings by at least one tribunal balanced out against the right of claimants to be free from expropriation and unfair conduct. But again, all of a balancing that's done. The other aspect of this was that it actually went on and on even after the award was issued. I think every possible recourse was taken after the award was issued. So it went on for years and years after as well. And in the first instance was annulment. So as I mentioned, in the ICSID system, there's no right of appeal. There's no second guessing. It's a final and binding award that is subject to what is considered very, very narrow annulment grounds. There's lots of jurisprudence by annulment committees formed on the ICSID system, making clear that their job is not to sit as a court or a committee of appeal, not to second guess the judgments of the tribunal, but to focus on very specific reasons why the award should not be enforced, and at a very high threshold. One of those is if the tribunal fails to state reasons for the award. So the idea there is, of course, process and justice. If the award just says, you lose, without any reasoning, that would not be upheld in the ICSID system. And so the annulment committee's job, that would be easy, that would be pretty easy, right? If you had an award that said you lose, that would be easy and subject to annulment. But for the most part, what it requires is the annulment committee to very carefully parse and to see if the tribunal's reasoning is sufficiently logical, transparent, there's no internal inconsistencies, that threshold of process, due process, is met. And that really was what the tribunal undertook. And the standard of review on annulment is the balance as a whole to understanding that tribunals need discretion in how they explain the reasons for their decision. So it shouldn't be annulment automatically if the annulment committee doesn't understand it, but at the same time, enough that there's there and due process is given. So it's a pretty subtle judgment. In this case, the annulment committee found that there was no basis to annul the tribunal's award, and it proceeded. And here, I won't go into it, but basically what the committee found is that you could see some inconsistency in sections, but it was sufficiently, I think they said, highly concise. And you can read in that it was probably too concise in places, but they could follow the reasoning perfectly well. And on that basis, there's a special degree of deference that applies, and it's not subject to annulment. So there's other aspects that come in on enforcement, rectification, and revision. Before I go into those, any questions or comments about this particular case? Yes, please.
Good morning, dear, and thank you for the presentation. I just want to ask about the effect of the annulment committees. What are the effect of their decision, how they see the judgments, and what are the outcomes for such annulment? Thank you.
Great question. So the committee, which I should have mentioned, is appointed by ICSID itself. So there's 3 members of the committee. The committee has basically 3 options. They can uphold the award in its entirety. They can annul the award in its entirety, or they can annul portions of the award. So if the award is upheld in its entirety, that's it. Game over. The award is subject to enforcement under the ICSID Convention. Everyone goes home. If it's a dismissal by the respondent state, the case is over. If it's a matter of the claimant getting a damages award, then it goes into payment or compensation or enforcement. So that is, if it's upheld, it's done. If it's annulled in its entirety, then the award doesn't exist. It's a blank slate, and the claimant would need to go back, or the respondent, if it's secured a dismissal, would need to restart proceedings. And in some instances, there's questions about whether the same tribunal can be appointed. The short answer is no, but there's lots about the annulment proceedings themselves that results in how do you restart a case post-annulment. And then perhaps most frequently is if portions of the award are annulled. That means, and say, for example, in this instance where the claimant had won on its fair and equitable treatment claim and its expropriation claim, if the FET had been annulled, then the claimant, if it wanted to lodge an FET, would have to reinstitute proceedings specific to it. And there, it's very specific to the claim that has been annulled. So that's one of the aspects of revision proceedings that's quite interesting is it within the scope of what the annulment committee has held? But it's usually a narrower case, usually faster, and certainly something that takes into account the findings of the annulment committee. But in some criticism of certain annulment committees is that they take it too far and act more like an appellate body than a committee of very, very limited function and jurisdiction. But it gives you a sense that it has lots of implications for whether or not an award stands full. Anyone else? Yeah.
I am Mabia Khatun from Bangladesh. I want to know about the Albania's claim that Albania claimed that the breach was contractual breach, not treaty breach. Mm-hmm. So here I am confused. Normally, I want to know that whether the treaty has any overriding effect like that. Normally what has happened that mutual contract get priority over general treaty or general law. So here, why Albania claimed that it was treaty, it was not treaty breach, it was contractual breach. So, about this, regarding this claim, what was court's observation in this case?
So I think that in that instance, so as you say, Albania was arguing that, look, there's a concession contract. That contract has a private ICC arbitration clause. This case, if the claimant wants to raise its case, it needs to go to a commercial arbitration under ICC rules. The question the tribunal was struggling with is whether this case was actually only about the terms of the contract, or, and I think that what the tribunal found was it wasn't just about the terms of the contract. It wasn't about Article 1 was violated, Article 3 was violated. It was more about the misuse of police powers in a way that implicated protections of against unfair, arbitrary state conduct. So what they became convinced of is it wasn't a regular contractual dispute. It was really about substantive investor protections. And that's why the piece that I read to you about that they found that the exercise of police powers in the criminal proceedings was pretextual, that linked into how the tribunal was viewing the sovereign acts as unfair, discriminatory, and abusive power. And that, to them, put it into the realm of the treaty breach versus a contract breach that just goes to the ICC. But it was certainly an argument that they spent a lot of time, briefing, arguing, and the tribunal ultimately was not persuaded by the reasoning that it was a pure, regular commercial contract breach.
Yeah, thank you.
Yes.
Hi, Stuart from Australia. I have so many questions. This is all very fascinating, but I'll try to limit it. On the screen here, you have almost a decade of work. Is this representative of disputes in this forum? And you were involved, so without prejudice to your client's privilege. What could we have done better to make this more efficient? Is there a policy change that we could institute for case management to make things more expedient and efficient? I'd be grateful for your thoughts on the policy aspect of this.
It's, again, a great question. And I'll take it out of the context of this particular dispute and just more generally speaking. I would say that international investment arbitration takes too long. It typical takes 5, 6, 7 years to resolve by the time, let's say it's bifurcated and there's an initial jurisdiction admissibility phase, and then you get to a merits phase. Sometimes it's trifurcated into a separate damages phase. And so as you add these phases and the months that it takes to produce memorials and evidence, you're looking at a 5 to 6 year process, which is typical. And that's actually one of the criticisms of the entire enterprise is that too long? And in the ICSID system, for example, one point of, I think, public debate, which I certainly have my own views on it, is whether or not annulment committees have gone too far. So one of the reasons you're looking at a decade of proceedings here is because, and in this case, it wasn't just, the annulment committee ultimately dismissed Albania's challenge. But in other instances, there has been a debate about whether annulment committees were starting to act more like appellate bodies. They were substituting their own judgment for that of the tribunal, which you're not supposed to do. But the annulment proceedings therefore actually add time. And especially if ultimately the annulment committee decides to annul aspects of the award, then that aspect needs to start at ground zero. So again, you're adding time. And then there's revision proceedings, rectification proceedings. There's lots of procedural opportunities if one were so inclined to extend the life of these cases. And this is the reason I use it as an example is every single procedural door was exercised. And so you start to see why going on a decade, the dispute persists. So answer to your question, when we get into the final part about what is UNCEDRAL Working Group 3 doing, one of the points of reform is thinking through what would make it more efficient. Having said that, there has been quite a push to actually disturb the finality of these awards by creating an actual appellate body that would be able to come in and do an appellate, potentially de novo review of everything that the arbitral tribunal has done. Now, there's some benefit to that in the sense that there's greater accountability in the system, opportunity to reverse unjust determinations by tribunals. But the flip side of that is you've just added 3 years to the process. I'm perhaps exaggerating, but not by much, by having an appellate process that sits on top of what was supposed to be a streamlined arbitration procedure. So it is not without cost, but that is exactly the balancing that is being done by states in the Working Group 3 process. So I think potentially, to directly answer your question on efficiency, if states decided that they were content with the system, don't add additional phases. but there's some political risk there in terms of endorsing finality in that respect. So, as with all things, I think it's a balancing. But I worry, my own view, I worry that we are not sufficiently valuing efficiency. If these disputes start to routinely take 10 years, you've really lost something in a transnational system of justice. And I'm not sure in the current political moment that efficiency equity is being sufficiently considered by states. But this is a state-created mechanism, and this is going to go where states take it. But it is one of the issues is efficiency. How do we make this more, not less efficient? And I'm not sure I see a lot of vision there in the current conversations. Yes.
Thank you, Professor, for the great lecture. I'm Masarat from the African Union. In your opinion, what could be the reason for the tribunal to focus more on how Albania's actions affected the investors instead of whether Albania had a good reason for its actions? could Albania have avoided liability if it had explained better to the tribunal? I would be grateful to your views. Thank you.
It's, as you can imagine, much of the argument was around exactly that question. Albania had to demonstrate that its exercise of police powers was for reasons having to do with actual allegations of money laundering, having to do with tax evasion, and not because it was an independent media channel that was criticizing the government. That was basically what the tribunal was grappling with. And ultimately, when Albania came forward and said, here's the evidence of this, this, and this is why we acted this way, the tribunal decided it wasn't convincing. But that is exactly what they were weighing when they decided it wasn't convincing. What was also interesting is if you parallel how the tribunal was looking and viewing Albania's evidence of legitimate exercise of police powers, and you compare that to the UK extradition court that considered Albania's application to extradite the claimant back to Albania so he could be subject to criminal proceedings, rejecting Albania's evidence, you see almost a parallel of the UK court also approaching this with a great deal of skepticism as to whether or not it was legitimate police powers versus pretextual. But it gives you a sense that I think that these are very difficult issues for arbitral tribunals to grapple with, because if you have a sovereign state saying we're exercising and enforcing our criminal laws, that is surely subject to a great deal of deference. Arbitral tribunals should not take lightly the exercise of legitimate police powers. Here, and part of what was a bit kind of nuanced about the tribunal's decision is they clearly weren't convinced it was legitimate. And that was the basis. I think they looked at Albania's evidence and found that it was not a legitimate exercise. And for comparison, I think the UK extradition court's kind of interesting as well. But it is a very difficult determination, and it's where you see investment arbitration hitting public order, legitimate desire to regulate, and how the balancing plays out with tribunals based on certain facts. But that's the crux of it. That's the difficult part of these cases, yeah. All right, yes. I like that you kept the microphone. It's good. It's bold.
It was the foresight of our colleagues from UFA. So I was just wondering if there are any other safeguards within the arbitration process which prevents the reopening of a case after the awards phase. So besides limiting the scope of an annulment committee, are there any other measures preventing, say, a state or an unhappy claimant from refiling the case on grounds of new evidence or while the lengthy process is continuing?
It's a great question, and it actually dovetails with what I'm about to show you, which is these post-award phases, enforcement, rectification, revision. You see actually that sensibility and the standards for rectification, which under Article 49 requires that under that article is address situations where you need to rectify any clerical, arithmetical, or similar error to the award. So very narrow, right? It is do not revisit an issue. It's literally you got the math wrong. Albania did invoke that, presumably beyond got the math wrong, and it was rejected on the basis that it wasn't narrowly focused. So that's rectification. The other is with respect to revision, and I've got this language up for you, but and I'll just read it. It's on the ground of discovery of some fact of such a nature as decisively to affect the award, provided that when the award was rendered, that fact was unknown to the tribunal and to the applicant, and that the applicant's ignorance of that fact was not due to negligence. So this is Article 31, and 51, and what is being balanced there is the idea of finality, but not entirely closing the door. There's an opportunity that if an award is issued, and then there's a material fact that sheds light on there was some grave injustice. I'll use that. That's not the language that's used in the rule, but gives you a sense of the threshold that must be met. Some grave injustice because of the new fact, you can reopen the door. Very high threshold. Albania attempted to use this on the basis that there was a criminal conviction after the fact, and I'll just go through it here. So they thought revision of the award in light of the claimant's recent conviction in Albanian court of certain illegal activities. So at this point, remember, the claimant's in London, award has been issued, the Albanian criminal proceedings go forward in absentia, and there's a conviction. So Albania came back and said, this is a new fact. This is a new fact that means you basically have to reopen the award and the proceedings. And they said that while the illegal activities themselves predated the award, their unlawful and criminal nature was only ascertained with the judgment that postdated the award. So it was the same underlying facts that the tribunal had considered, but the new fact was the fact of conviction. And the tribunal found that that wasn't sufficient. They found that a domestic court's post-award legal characterization of a pre-award fact cannot constitute a new fact for the purposes of a revision application. And so they said it is, quote, clear, certain, and obvious that Albania did not discover any pre-award fact justifying revision of the award, and the revision application was manifestly without legal merit. So, take a step back. Basically, the revision tribunal was communicating to states that you can't make a fact new by simply continuing on with the lead criminal proceedings, getting to a conviction, and then saying, okay, now there's a conviction, we're going back, because all of those findings still hold. And if that were the case, it would be pretty easy, actually, to disturb awards. You just keep going with criminal proceedings and then come back and try to revise. So the tribunal was quite clear that this didn't constitute the extraordinarily high threshold that justified revision. But it does, in answer to your question, give you a sense that there are provisions under the ICSID that it's all about the balance, trying to make sure that there's no miscarriage of justice, including on the basis of a new fact that might arise after the award. All right. I was going to go into kind of some of the next steps in reform of ISDS, but before I do that, are there any other questions about process defenses? I'm happy to answer that. Please go ahead.
Thank you. I would like to ask further questions about the positioning of customary international law. Mm-hmm. As you mentioned on the presentation, I saw that in the U.S. model BIT, there is a clause or provision regarding customary international law, for example, in the context of fair treatment, for example. And my question is, in the context of arbitration, how would the arbitrators or how would the parties decide or argue about the scope of the customary international law when customary international law itself develops over time? What would be the basis, and would there be any main references for that for the parties to argue over which CIL to be pursued in the proceeding? Thank you.
Great question. The short of it is yes. There's lots of scope, and I've argued on both sides, actually, both that something is CIL or resisted that point is CIL. And it comes down to the usual test for establishing custom in the sense of state conduct, opinio juris. Are they doing it as a sense of legal obligation? Is it pervasive enough to meet the very high threshold of establishing custom? So all of that is part of what a tribunal would take into account. So both sides argue there is custom established, there's no custom established. A lot of the ILC very good work on customary international law is invoked by both states. Different state positions are invoked, commentaries, but it tends to be a very, very robust argument around whether or not custom is established. Having said that, there are certainly, there's jurisprudence that, for example, on the U.S. position, and the U.S. has long taken the position that the customary international law standard is what's manifested in the treaties that the U.S. is party to in the BITS. So no more, no less, it's the customary international law standard. So there's lots of jurisprudence as to what that does and doesn't mean when it's compared to FET. So legitimate expectations, for example. Is that customary? Is that something that rises to the level of custom? It's a very good argument that it does not. And so you'll see in these tribunal decisions, discussions of custom that is very reminiscent to how, for example, the ICJ approaches the exercise of determining whether or not there's custom, and the ILC working group and all of that informs it. I will say that it's very interesting. The ICJ is one thing in terms of actually establishing custom. The idea that three private individuals sitting in the context of an investment arbitration would find new rules of customary international law has struck some people as quite controversial. And certainly when it comes to states, what constitutes custom is of paramount importance because you are bound by custom regardless of whether you signed up to a specific treaty, right? It binds all states. So it has to be a pretty stringent standard, and that's the approach that many states take. So it's one of the examples of, in some sense, criticism of investment treaty tribunals if it's felt that they're getting too far ahead of states in what some call the inappropriate progressive development of customary international law. So it's a great question, and it's certainly something that I think is of particular import when it comes to investment arbitration tribunals. It may be one reason why lots of tribunals are quite conservative about dealing with the questions of custom, and appropriately so, because it's arising in this particular context of investment arbitration. Yes?
My intervention actually or question is regarding the balance between investor rights and the public policy space. There are recently, or we read recently online that there are many critics that say that investment arbitration always favors the investors and undermines the state regulatory autonomy. And this is why we find that many countries, for example, which I discussed during the break with my colleague, that bilaterally, when we have a trade agreement or economic agreement, many states put a clause saying that in case of dispute settlement, the states do it amicably via diplomatic channel and by negotiations because they want to remain conservative, afraid of that matter. And this automatically creates an impact on the codification of the international investment law. So the first part of the question, what do you think of those critics? And the second part, what concrete reforms do you believe that are mostly necessary today to balance investor protection with a state's right to regulate in public interest, particularly in developing countries? Especially that in arbitration we find many risks that are related to political backlash, domestic controversy, leading to non-compliance lots of times.
Terrific. I mean, your questions are also excellent because you're anticipating where I'm going, and you're actually anticipating exactly where I'm going with this next piece, which is critiques and reform of ISDS. I think I mentioned this at the very outset, in that we are in a moment of crossroads when it comes to the ISDS system. So, you know, we're almost 60 years into the system, and there certainly has been, in the last 5 years, I would say probably a bit longer than that, a significant state-driven criticism of the system. In some sense, early critics were in some sense dismissed because Argentina, for example, having been one of the states that had the most awards that were outstanding against it, that it was not fulfilling, came under some criticism. And then there were other states like Spain on the ECT awards. And you start to get a sense that states had a reaction to the situation by asking the fundamental question you're asking. Is the balance correctly met? Yes, there are investor protections, investor rights. There's a commitment to non-arbitrary, non-capricious, non-discriminatory conduct, right, on the one hand. At the same time, is the current ISDS system adequately protecting a state's right to regulate, especially around these public order, very important rights, environmental, human rights, whatever it is? And that is the classic question. And to answer your question, what I try to do here is capture what is a conversation that's going on internationally in the context of UNCITRAL Working Group 3. But to give you a sense of some of the criticisms that have been lodged, and you actually echoed some of them, on the substantive inconsistency. There's a sense that sometimes you have tribunals who are looking at similar or analogous facts and coming to different conclusions about whether or not state conduct is justified, and what does that say about the legitimacy of the system. You have the idea that the definition of investor is getting broader and broader, that criticism, that it's getting all-encompassing, that there's treaty regimes that have arisen that lead to fragmentation and inconsistency, and then there's power inequities where developing states are too often being held liable for failing to meet investment protection standards. So all of these criticisms are out there and part of the public dialogue. That's on the substance. On the procedure, arbitrator selection bias, there's been lots of commentary that the pool is too small, it's too biased towards potentially Western-oriented interests, but lots of commentary on what arbitrators are doing. Are they selected in a way that favors claimants inappropriately is another criticism. The lack of transparency and public access, this goes back to the conversation we were having earlier about confidentiality. The flip side of that is that these are public order norms and there should be a presumption of transparency. And then to the other question that we were just talking about, delays, inefficiency, why should it take 6-7 years for these disputes to make their way through to a final award? So this is what the United Nations Commission on International Trade Law is grappling with in Working Group 3. It's a state-driven conversation, state-driven potential reforms. There's an arbitrator code of ethics that has come into the conversation. There's the mandate very broadly is to work on potential ISDS reform. And the reform mechanisms are really diverse in the sense of what's being discussed. There is, I think I mentioned, potentially a standing mechanism for the resolution of international investment disputes. There, the key is to make it effective, because if it were something that could be itself criticized for bias, maybe in favor of states, it's not going to be used by investors. It's going to have an potential effect on FDI. So that's part of that conversation. There's provisions on procedural and efficiency issues. There's a potential draft multilateral instrument on ISDS reform, and including potentially an appellate body, an opt-in convention that will allow states in certain situations to opt into these various reforms. But needless to say, is we track this pretty closely because there are some serious reforms of ISDS that are being discussed by states and all around really good and core concerns and considerations. From my perspective, these conversations, some lament them as being biased, that there really is no claimant bias in the arbitration system and that it's being driven by states that have been too often losing in these cases because they fail to protect investors sufficiently per the treaties. But I actually think that wherever the impetus for this discussion, it's very good for states 60 years later to revisit and own the mechanism for dispute resolution, to weigh the efficiency and the policy mandate, right to regulate, to bring all of this out into the open and have these discussions. Where it goes, I don't know yet. It could be that an appellate body opt-in is something that lots of states, including the EU, are in favor of. That's going to add years, and we're going to have to deal with what that means for the justice system. It could be that they put up a standing court, an investment court, and depending on how the judges are appointed, it could be quite effective or not effective. It all depends, and the devil is in the details on all of these initiatives. But from my perspective, the fact that states are taking control, having these conversations, and have a forum in which to discuss real efforts to reform, to me, is really, really important. So all of this to say is that this remains TBD. We're going to see where the states end up. I suspect that there will be a standing court, an investment court of some form, and that where states will have the opportunity to opt in. How well that works, we'll see in the coming years. But I think one thing that's agreed is that these kinds of disputes, the ability of claimants to raise investor disputes and the link that has to foreign development investments is really, really important. So it's something that will persist, I suspect, in some form. ISDS in some form will persist. The actual form that the states will settle on, I think we'll see. But again, where I end up looking at the tea leaves is there'll probably be a standing mechanism, maybe an appellate body and an opt-in, and then states will vote with their feet. They'll decide if this makes sense to add layers in terms of the dispute resolution process. But something is going to be there, I think, and continue to be there because of how important these investor protection systems have become in the international legal architecture. So that's my guess, but happy for anyone to have a contrary view or tell me what you think is going to happen. But that is, let me look at the time. Okay, we've got time. So if there's any questions, I'm very happy to address questions. Go ahead.
Thank you so much, Catherine. That was such a comprehensive presentation. On the first day, or maybe it was the second day, Dr. Philippa Webb, thank you, talked about immunity from jurisdictional immunity of states as well as execution immunity. And one of the issues that we see coming up in investment arbitration is awards that are being rendered against states and then questions about compliance with those awards. And leading on to the post-award phase, you discussed some of that with revision or interpretation of awards, but there is also execution and enforcement of those awards. And I guess the larger question that I have for you, connecting Dr. Webb's presentation where she gave examples of where state assets are immune or not immune, the consent to jurisdictional immunity being waived through arbitration agreements or these treaties. In the larger system of ISDS reform, do you have any thoughts on connecting not just the arbitration through to the award, but then the next phase of potential compliance and the law of immunity that's relevant?
It's a great question. I don't think that the enforcement concerns have been the crux of the Working Group 3. So I guess the question is, where is that conversation being had? As I mentioned, the Libertad was just one example of a very high-profile moment where you have sovereign asset, a classic, a naval vessel, being attached as a result of an award that comes out of the investment arbitration system. And the questions that were asked around it is sovereign purpose versus commercial use. And as you know, in the United States, the FSIA is one of the most deeply contested kind of mechanisms of litigation. So the question of what is sovereign use versus what is commercial use has always been difficult, fact-bound, and nuanced. And in some instances, for example, sovereign pension funds have been attached because there was some rationale that connected it to commercial use. So it's messy, in my view. Is it subject or susceptible to some kind of systemic reform or clarification? I'm not so sure, because it is so difficult to come up with general rules other than what we have, which is sovereign use versus commercial use. And as you say, there's lots of exceptions, commercial activity exception. If you accept arbitration clause, is that enough for that commercial activity to be lodged or demonstrated? It seems to me that it's as clear as it's going to be, and that we're going to have to live with that messiness. But I'd be interested in your perspective if you think that there's something more systemic that we can do around immunity issues, because I agree, it causes a lot of stress and tension in the system. And it's interesting because when ITLOS actually ordered that Ghana had to release the Libertad away from the seizure order, it actually said that this causes friction and threatens peaceful relations between sovereigns. So it gives you a sense that the stakes are extremely high in these kinds of cases. So I would love for there to be some easier solutions so that that friction dissipates, but I can't think of a good one beyond the lines that we've currently drawn.
Happy to know that Professor Webb also covered this example in her presentation.
Oh, did she?
At a similar point, so there's a nice coming full circle there.
Good.
I guess the only comment I would think of is any way to address the friction, perhaps is in investment contracts, where you could contractually discuss, pre-attachment waiver of immunity, jurisdictional immunity, execution immunity, and depending on both parties negotiating balancing power and also what the objectives are from that specific contractual arrangement, address some of the questions that come up later. I think in the treaty context, it's harder for the reasons you say, and we might have to live with the messiness in statutes in different countries and sort of the law on sovereign immunity generally at the customary international law level.
Yeah, that's interesting, because I think one analog is that I've seen in the context of M&A transactions with SOEs, state-owned entities, they actually do try to be explicit in the M&A transaction, in the underlying transactional documents, as to what constitutes sovereign assets in the event there's a dispute. They're trying to anticipate that you can't necessarily pierce the veil through the SOE and get to the state's assets. So that's an example, I suppose, of on the transactional side, where there's some attention and care being paid before a dispute even arises as to what is and is not commercial use. So that kind of clarity, I think you're right. It's if you can bake it into these individual kind of deal documents, that's also very helpful. Any other questions? Yes.
Thank you very much for your presentation. It's a very important and interesting presentation. I'm thinking about the ITSID. I think I don't understand very well the correlation or the relation between the ITSID and this investor-state dispute settlement. Is this procedure under the ITSID?
It's a good question. I wish I could throw up a clause for you to see. It's actually in the bilateral investment treaties themselves, in the dispute resolution clause. There's some treaties that say that an arbitration can be initiated pursuant to ICSID convention, which takes you into the ICSID convention. And there's others that say ICSID convention or UNCITRAL. And there's others that say maybe there's a third option that they put in. So in the bilateral investment treaty itself, it designates which forum is available to claimants. And the ICSID convention and the rules that arise under the ICSID convention is a separate multilateral treaty that many states have ratified. And under the ICSID convention, they agree to certain procedural rules that apply to these kinds of arbitrations. And in the event of an award, what kind of deference is given in terms of enforcement of the award. So it's actually, all of it arises under the relevant bilateral investment treaty or regional investment treaty, and it's the dispute resolution clause that determines what forum is available to a particular claimant.
Thank you very much. Yes, I see that is a separate procedure that has nothing to do with the ICSID. But I fear that it might be conducive to certain, in the future, to certain overlapping with the functions of the ICSID, because there's already a body under a convention established to deal with disputes between investments, foreign investments, and states, which is the ITSID. Mm-hmm. And now we are going to have another, perhaps, convention, you mentioned as one of the options that the UNCITRAL is thinking about to deal with disputes between foreign investors and states. So I think it is going to be a sort of repetition, and perhaps there will be overlapping. I don't know, what would be your opinion? Thank you.
I think you're absolutely right, and that's part of what triggered my observation that I'm not sure the reform conversation is sufficiently taking into account, efficiency considerations, because by creating these multiple potentially overlapping regimes, there's a proliferation of mechanisms that may actually do more to confuse how these disputes are handled than help them be handled in a just manner, which is what everybody wants to get to. But I agree with you. I think that's why I said that states will ultimately have to vote with their feet. If they do stand this up, then states are going to have to decide, do you want to opt into a standing mechanism, a standing court? Do you want to opt into an appellate body? And so in some sense, if we see how states align themselves with these various options, then it may be that we start to see that instead of overlapping, it synthesizes into a cleaner kind of system, more efficient system. But I'm skeptical, because proliferation of mechanisms rarely leads to more efficient systems. But as I said, I think a lot of the UNCITRAL Working Group 3 conversations are going to have to figure out exactly how to hit that balance. Yeah.
Actually, my question is based on your own assessment. Which system you see preferable for investors? Is it the UNCITRAL or the exit, as you used to say?
It depends. It depends. There's some, in some sense, the one advantage, for example, of the ICSID system is that it's self-contained. There is no domestic court that sits in judgment of the award. It goes to an annulment committee. And under the ICSID convention, the award is automatically treated by every state that is party to the ICSID convention as a judgment of its highest court. So it's automatically got that internal recognition. So there's less steps involved. It's entirely self-contained. And there's some sense that that's quite efficient and advantageous for claimants. On the other hand, there's potentially more rigorous tests that apply that could narrow the ability of claimants to actually bring successfully investment claims. So I can also see in some circumstances where the claimants go for UNCITRAL, which is subject to the New York Convention, which is subject to set-aside proceedings in courts, in domestic courts under the New York Convention. But that would still be preferable because there's more of an ability to more flexibility around the nationality, what constitutes an investment, et cetera. So it really is very much a matter of particular circumstance and what strategic advantage each of the systems actually provide. But definitely a longer conversation on that one. It's a really good question. I think there was a hand over. Great.
I'm afraid I'm going to take you back a few steps and ask a very basic question.
That's okay.
So I was just wondering, you mentioned about the claimant seeking expropriation of the property, that issue. So in that case, does the tribunal take into consideration only, like in the case of the channel one, the channel broadcasting channel case which we discussed, only the channel, that property into consideration? Or I think that particular investor had other properties also in the state. So is that also taken into consideration by the tribunal, or does it factor anywhere in the whole proceeding?
The short answer is yes. There were actually a multitude of claims that the claimants in Hydro brought having to do with energy investments. The tribunal denied the energy investment claims as not meeting the standard for expropriation in FET, but granted the media channel claims as being an expropriation in violation of FET. So the tribunal did look at different assets and see individually, did those assets rise to the level of a treaty breach?
Hi, I'm Nikhil from Mauritius. I'm having some trouble reconciling the ability of an investor to restart a claim after an annulment procedure or partial annulment. I saw in one of the slides that there was a limitation period of 3 years before whereby a claim could be started. Given the timeline that you have shown between actually starting a claim and then reaching the annulment award or annulment procedure, has there ever been like an objection raised about a new procedure starting because of the 3-year limitation? And the second part of that question would be, does it put too much pressure on the state to preserve documents if ever a new claim is started or there's a partial annulment, and then one has to go back and look at all the evidence or documents that might help the state in disputing the claim?
Great questions. Really, you guys are very impressive. In terms of the actual, let's say there's a statute of limitations that applies in the treaty, no, because the annulment is seen as an extension of the same proceedings. So as you can imagine, depending on how long it takes, it would be, I think, unfair if after annulment, a claimant were prevented from rightfully restarting a portion of whatever it needed to because the statute of limitations now preclude the claim. So the short answer is no, because of these tolling provisions that apply, which allow the claimants to treat this as one claim. So what matters in terms of the statute of limitations is when it was actually filed. If the initial filing falls within the statute of limitations, that typically will carry through. And then the short answer on the burden on respondent states in terms of documents, absolutely, which is why when you add potential mechanisms that adds time to these proceedings, there's a real burden. Because you're right, the sovereign state has to be in a strategically protective strategy, which would include preserving documents that may be material or relevant if after annulment a claimant is entitled to redo a portion of their case. So that is absolutely right, that there is a burden that's placed, but this is where the conversations with counsel are going to be so important to make the strategic judgments of, look, what do you do with these documents? Perhaps it's better to just put them into storage or a warehouse just in case, but that requires counsel coordination. But that goes back to my point of there's a real burden that's placed. The longer these proceedings go, there's a real burden that's placed on states. Yeah.
Thank you very much for very fascinating, comprehensive, and profound presentations on all the important aspects of ISDS. I'm from Japan. I'm a director for economic dispute settlement. So taking this opportunity, I have one question, but before that, I'd like to probably share a very limited Japanese experience of ISDS. My office was created only 5 years ago in 2020. In 2019, we had the first and the only case so far of ISDS. We were sued by an investor in Hong Kong. So in the history of Japanese investment treaties, we have benefited a lot by having our Japanese companies suing other states. Maybe we have had nearly 10 cases where Japanese companies sued foreign governments, and we have seen investment treaties as significant as a tool to promote foreign direct investment without thinking much about the risks that may entail for the government of Japan being sued. But this case, this first case in 2019, really opened up our, eyes about the risks of ISDS, and then we decided to create my office. We have had a lot of, trainings and so forth. So I think the point that Catherine made about the capacity building and the top 5 key points that she had elaborated are very, very important for us, and we would like to probably share in the future with your governments, the member states of ALCO, about the experiences of each country, because it'll, I think, enrich our expertise. So I think this opportunity to get the very comprehensive overview about the ISDS and its challenges together with all the ALCO members are really a great one, and we very, very much appreciate your presentation and your participation and all your questions. Japan had only one case so far, and we are very much in the learning process, and we learned very much today. One question is about the current trend of governments introducing more and more regulations for the sake of national security. And in Japan, we have more and more political and domestic interest in that regard, and more, let's say, domestic pressure to put in place more regulations on direct foreign investment in Japan. When we have actually more and more foreign investment in Japan, well, this is something different that we have envisaged like 10 or 20 years ago when we were interested in investing abroad. So I heard that there's a case, for example, where a Chinese company suing Sweden on the basis of their, some regulations, ongoing case. So my question is about well, of course, there's no answer to this question, but what do you think about this trend of, the government's or the state's focus on economic security and how it would impact the future of ISDS? Thank you.
That is thank you for the observations, which are excellent. And I think you've pointed out something that in an increasingly fractious world, especially with respect to trade relations, I mean, witness what's been going on just these last several months, tariffs on, tariffs off, and the disruptions in supply chains, disruptions in trade relations, there may be more appetite by states, and in fact a demand on states to look at foreign companies in particular that are operating within those jurisdictions and make sure that essential security interests, for example, are preserved. And in the world that we're living in now, that is even more fractious, more polarized, I can well imagine that there'll be more of, for example, in the Chinese and Swiss regulation context, the Swiss felt almost a public imperative that they had to deal with the national security criticisms, including for Chinese companies operating in their territory. And that regulation was an imperative for the Swiss government. I think that more and more governments will find themselves in that particular situation when it comes to essential security and national security. And I say that with a heavy heart because I think that is going to be a byproduct of increased fractionalization across the globe when it comes to trade relations and other rivalries, whether they're regional or global. I know, for example, from the US-China context, there's going to be a lot more nationality-based measures that are taken. And whenever nationality-based measures are taken, it raises the question of these treaty protections, which are specifically geared towards an equal protection approach to the rights of foreign investors. So I think I see us coming very much into increasing tension. And the example that you gave to me, we're sitting on a threshold of a significant uptick in those kinds of disputes. But I suspect you may agree with that observation, but would love to hear your perspective on it as well.
Yes, I totally agree with what you have said, and there are increasing tensions between this, international standards of protecting investment versus national, security requirements. And the point that you have made about the how to articulate your regulations in a way, in a non-discriminatory manner is the key. So I think it's not a secret that we may have some specific, let's say, countries or areas in mind, but we do not. We try to create norms, rules, non-discriminatory, not on, of course, national base. That is really the key. And one of the challenges is that because there are mounting political domestic pressures, and there are offices who are very actively engaged in that process and try to create new regulations. And legal office, especially the defensive side of the, in charge of ISDS, are not, shared. All these, new works could happen. So we try to engage with all the other, relevant offices. So kind of active, I think, defense is very, very important. Thank you.
Absolutely. No, thank you for sharing. I think the themes that you've touched on are going to be more and more important and growing importance. And as you say, coordination, get ahead of it, try to come to some synthesis. But the national security point in particular, we're going to have disputes where tribunals are going to be testing the national security rationale of sovereigns, which is very difficult because from an evidentiary perspective, you often have classified or other information that is relevant to the national security determination, which is not appropriate to be shown to an investment arbitration tribunal. So that particular type of dispute also has its own very significant strategic sensitivities. We have two over there.
Thank you, Professor. You mentioned that a conviction would not be a sufficient ground to warrant review of an arbitral award. And I'm wondering, what are some of the compelling reasons that would prompt a tribunal to review an award?
It's a good question, a follow-up to that. The reason in that particular case the tribunal found that the conviction was not sufficient was because the conviction was based on the facts and circumstances that were already before the tribunal. So found that the fact of conviction wasn't new to warrant upending the award. It could be, though, in some circumstances where the underlying criminal conduct is actually new in the sense that it arose post-award, is not new in the sense that it was pre-award but unknown at the time for whatever reason. And so it comes to light only after the award is issued. In those circumstances, I think tribunal could come to a completely different conclusion. But in that revision matter, it was all about the fact that all of this was known to the parties, the underlying allegations of criminal conduct, to the parties, to the tribunal. It was litigated, it was assessed. So the mere fact that that domestic proceeding resulted in a conviction was not something sufficient for revision. But I could imagine other circumstances in which something comes to light that really causes a tribunal to be concerned that the award itself was not based on sufficient evidence. I think way in the back.
Thank you. I have two technical questions. The first is on the arbitral selection. You mentioned that we have to focus on many things about the arbitrators, not just about how those arbitrators found on the substantive obligations, but also about the coordination. And you mentioned that we should that's something that the council would know. But I was wondering if there's any suggestions that the governments could also have a first-in-hand knowledge about those arbitrators, as that's the most important phase of the arbitral process. And I was wondering if there's any way not only relying on the council's advice, but the governments could also have any way to understand the arbitrators before we appoint arbitrators. So that's the first question. And the second question is on the counterclaims. Even if all disputes could include counterclaims, I was wondering if there is any argument that investors themselves did not consent to the counterclaims jurisdiction. It's only the states that accepted the all dispute jurisdictions, but not the investors. Thank you.
Great. On the first, absolutely. In my view, all sources of information when it comes to arbitrator candidates should be employed. So, of course, and there are some states who have dealt with investment disputes and who have knowledge of how certain arbitrators approach issues, and that would, of course, be relevant. So when I said that counsel would be a particular source of that, it's not exclusive. From my perspective, any and all sources, including from state contacts, would be important in that assessment of arbitrator candidates. And then on the second, it's less a question of the consent of the claimants to counterclaims and more within whether it falls within the jurisdictional scope of the arbitration proceeding itself, which is why the treaty language and all disputes is very much what tribunals have focused on. But other tribunals, for example, have noted that all disputes isn't sufficiently specific to allow counterclaims, and that what the treaty contemplates is only a one-way ratchet, which is a claimant claim against a respondent sovereign. So there are other decisions that I didn't show you that go the other way and say, nope, there's no counterclaim jurisdiction here because this treaty is only about investment claimants against sovereign respondents. That rationale, I think, is also embedded in the point you made, which is there some notion of unfairness? Because a claimant, by exercising its treaty right, being subject to a counterclaim, is there some unfairness or surprise? So it's less about a question of consent and more about what does the treaty contemplate? Is the language broad enough so that jurisdiction is conferred on the tribunal? And there's decisions that go the other way, where I think there is some sense of the unfairness that's visited on claimants in that way. But that's typically how it's discussed. Okay. We got two more.
Me first?
Sure.
Okay. Thank you very much for your presentation. I just wanted to a little bit shift our discussion, and I want to seek your own opinion regarding the third-party funding in arbitration, because I'm from Uzbekistan, and what's right now happening, we have a lot of investors, and apparently we have a lot of disputes, but sometimes not all the disputes are brought to the arbitration, so they are kind of like sleepy regime. But all of a sudden, they started bringing these cases into arbitration, and sometimes the amount of claim is less than the cost of arbitration. And what we started finding out, there is a TPF agreement behind of this. So I want to know what's your opinion. How do you assess that kind of so-called TPF's agreement mechanism? Is it another opportunity for investors to have an access and protect their rights, or is it some sort of mutation which actually jeopardizes the whole arbitration system?
I think it's that question about TPF and the role that it plays is precisely why that in most instances there is a disclosure obligation when it comes to TPFs. Because that question about whether or not this is an abuse of the system, an abusive process, because unmeritorious claims are being funded by third-party funders who then take a percentage of whatever damages comes out, is it a proliferation of unmeritorious cases, or is it access to justice, right? It's exactly the debate that you've just identified. I think that disclosure of TPF arrangements is going on. I mean, it's been several years now. I think it's maybe 7, 8 years where it's become fairly routine to disclose TPF arrangements. I have not seen an empirical study that actually demonstrates or proves the criticism initially, which is TPF results in the proliferation of unmeritorious and frivolous disputes. I could be wrong, but I have not seen yet a demonstration that that is the case. And so to me, that really begs the question, is there a problem? Is there something where there is a proliferation of unmeritorious disputes? I haven't seen it, but it could be that it depends on the circumstance. It could be that in your country, yes, there is a problem. The other thing that always strikes me is that these funders are doing an economic analysis. They are putting money at risk and doing so on the basis that they think they'll win. And so structurally, you have almost a rigor imposed because of the economic rationale. So unless there's some kind of nuisance or some bad faith reason why they would be bringing a claim, usually it's an economic rationale. And if it's an economic rationale, they, presumably with the advice of knowledgeable counsel, came to the conclusion that it was not a frivolous claim because it could possibly win. So I wonder if there's also some rigor imposed by virtue of the fact that these funders are in it for the money, so to speak. And so they're making these analyses on that basis. But until there's a study that demonstrates that they throw off frivolous disputes such that there's a systemic abuse of the system, I think they're here to stay for the foreseeable future. But I do think that the disclosure allows respondent states to see if there's an issue. Is there a bad faith? Is there something that disqualifies the claimants because of the nature of the funding that they've secured?
Thank you very much, Professor, for the wonderful presentation. So my question is basically to ask whether you have any experience on the flip side, yeah, because for the Albania context, there was sort of the abusive exercise of power by the state, so to speak. So whether you have any experience where there's been actually substantive protection of I'll give you an example. For example, in Kenya, let's say the protection of the rights of indigenous communities insofar as community land rights are concerned. And this was in light of a carbon offset project where there were some investors, and then of course there was a body that verifies the sort of the variability of the project to take off in light of the legal context and everything. So whether you have any comments about where there have been approaches to safeguard the interest of the public actually in states.
Absolutely. And something I failed to mention, but shouldn't be lost on this group, is that states win the majority of time in investment arbitrations. Claimants are still below 50% in terms of their ability to succeed. I believe states, and I could be speaking out of turn, so someone should check this statistic, but I believe the last study of how frequently states win had states winning more than 60% of the time. But there's good reason for that, which is, to your point, there's plenty of examples where the state is exercising an important public order right to regulate in defense of indigenous rights, in defense of the right to regulate any sector that you can think of. So for the most part, I think that the idea that the system is there just to vindicate and does vindicate claimant rights on investment is not right. That there are plenty of cases in which the respondent wins for very good reason. And I have been on the respondent side and seen the exercise of the right to regulate in a way that makes complete sense, and that you can see the opportunism of some claimant companies who are there having had a failed investment, who are seeking to hold the sovereign accountable when there's really no credible evidence of breach. So I've seen both sides of it, and I think that the right to regulate is really exceedingly important, and states win the majority of time in these cases. What's also interesting, though, is that there are these notorious cases, like, for example, the Philip Morris case, where you have a right to regulate in terms of tobacco use, which should strike everyone as significant, important public order good, and yet a claimant comes in and says that the disclosure of a potential for cancer on labels is somehow discriminatory, et cetera. And when tribunals potentially get things wrong, the balance wrong, those cases become emblematic for criticism of the ISDS system as a whole, which I completely understand, because when you have, say, bad examples or notorious examples, that takes on a life of its own, and it feeds the criticism of the ISDS system. And I think there may be part of the reason why the Working Group 3 conversations are so salient right now, is that there's a sense of inequity, that the right to regulate is being compromised. And the right to regulate is of paramount importance, is only becoming more important in the national security context, in the climate change context, indigenous rights, human rights. It's only getting more important, not less. So you're going to continue to see ISDS try to get the balance right, but I certainly, to answer your question, have seen both sides, and in fact, states usually prevail in these cases, and in my view, for very good reason. All right, well, thank you, everyone. This has really been a privilege and a pleasure. Your states are in very good hands with you. Really, these questions have been extraordinarily insightful, and I just feel privileged to be here with you. So thank you so much, and I appreciate the attention.